situation where one of your farm workers negligently caused a fire which damaged your neighbour's property. Did you know that you could be held liable for such an action? This is known as vicarious liability. Mark Christodoulou from VDT Attorneys is with us today to explain this possible foreign concept. Yes, quite foreign. Mark, welcome.
Thank you.
What is vicarious liability and which law is it governed by?
So vicarious liability is governed by the common law and the past case law on the matter. What it basically entails is that an employer can be held liable for the wrongful actions of an employee should they be caused during the course or scope of the employee's employment. This is quite a controversial topic, as you can imagine, because generally the general principle is that a person is liable for their own wrongful actions, whereas in this case it is somewhat justified because should the employee not have been attending to their duties in terms of the employment contract, they might not have been in the position that they were in, and they might not have committed the wrongful conduct.
Well, that explains it already.
Yeah.
What are the requirements for one to prove such vicarious liability?
Firstly, there needs to be the existence of a contract of employment, so an employee/employer relationship. This needs to exist at the time of the wrongful act. This is very important. There also needs to be a distinction between the employer and employee relationship versus an agent. If you are acting as an agent, there is no employer/employee relationship, and therefore an employer cannot be held vicariously liable. Secondly, the commission of a wrongful act. The employer can only be held liable if the act was delictual or wrongful in terms of the law. The requirements of this are a wrongful act which was wrongful, that is one of the requirements. There must have been actual damage that the party suffered and which was caused by the negligence or willful conduct of the employee. This must have been an act or an omission on the part of the employee. Thirdly, the employee needs to be acting within the course of the employment.
Right, Mark. So when is an employee acting in the course of employment that you refer to?
Look, it may seem like quite a simple concept, but I think it is far from that. The employee must have been engaged in the performance of his duties as required in terms of the contract that they have entered into. Just because the wrongful act was expressly forbidden by the employer, or if it was a criminal conduct, it does not necessarily mean that the employer is not vicariously liable for the conduct of the employee. One must also distinguish between course of employment, so where an employee acts during the course of the employment versus when they act during their employment. There are a few factors to consider, such as the terms of the contract, the nature of the work that needs to be done, as well as the factual circumstances which surround the wrongful act. It's clear from these factors that there is no clear-cut case or clear-cut requirements to any of this, and each case will have to be decided on based on the scenario at hand.
Mark, should an employer be vicariously liable for the act of an employee? Are they liable for the whole claim?
Well, to start off, yes, they can be liable for the whole claim. However, once a competent court has decided on the quantum and the amount that is due by the employer and or employee, the court may make an order that they are both held jointly liable, which basically means that should one pay the whole debt, the other is extinguished from paying the amount. Thereafter, the employer might have some right of recourse against the employee, and they may approach the court again to ask the court to apportion such claim or to reclaim the whole amount from the employee. This is all governed by the Apportionment of Damages Act, and once more is very dependent on the facts of the matter.
Well, don't go away. After the break, we'll be back with our discussion with Mark Christodoulou. Welcome back to our discussion with Mark Christodoulou from VDT Attorneys, and our topic of discussion is vicarious liability. Quite complex, Mark. You mentioned that each case will have to be decided on depending on the factual circumstances, of course. Can you provide an example of when an employer was held vicariously liable?
Yes, of course. The case of Viljoen versus Smith is a prime example of this, especially in the context of farming. This was a case which was decided on by the Supreme Court of Appeal. The facts were briefly as follows. Mr. Viljoen owned a farm and Mr. Smith owned the neighboring farm. During the course of his employment, one of Mr. Viljoen's employees decided to, while he was working on the vineyards, needed to use the restroom. There were no restroom facilities on the vineyards, and the closest restroom was back at the farmhouse, which was quite a distance away from the vineyards. It was expected of the employees that should they need to use the facilities, that they go before they commence with their work activities. However, should the need arise, they could just use the restroom in the vineyards. This employee had to use the restroom, and he decided to jump the fence into the neighboring farm and walked about 300 meters to use the restroom. Thereafter, he decided to light a cigarette, and while he was attempting to light it up, the match head broke off and caused a fire on the neighbor's property, which caused, of course, damage. In argument, Mr. Viljoen stated that the employee did not act in the course of his employment and that he acted during his employment, which, as I mentioned before, it needs to be distinguished. The court, however, disagreed with Mr. Viljoen on this argument. The court further held that on evaluation of the employee's actions, it revealed nothing more than the fact that all his only intentions were that he needed to relieve himself. If you had to have a look at the amount of time that it would have taken the employee to walk the 300 meters and walk back, it wouldn't have been too long, and the court found that this is not a substantial degree of digression of his duties. Therefore, Mr. Viljoen was held vicariously liable.
Sure. Wow. Can you provide a practical example of when an employer will not be vicariously liable?
Yes, of course. Let's say Mr. B is a truck driver and is employed by Mr. A. During his duties, Mr. B comes across a hitchhiker, let's call him Mr. X, and picks him up and gives him a lift. While he's driving, he lands up due to his own negligence in an accident, and Mr. X is seriously injured. The courts will find that Mr. A, the employer, will not be vicariously liable for Mr. B's actions, as Mr. B acted outside the course of his employment. It is not his duties to pick up hitchhikers on the way during his job. Other examples of when an employee will not be held liable are when the employee commits a wrongful act while busy with his own interests, which do not form part of his duties, or if a wrongful act is committed by the employee for the employer, but outside of his authority. For example, let's say a waiter decides to deliver the food to the customer without authorization, and on the way there he lands up in an accident and causes an injury to a third party. The waiter will be held completely liable and the employer will not be vicariously liable. There are instances also where certain employee contracts may state that an employer will not be held liable for any of the employee's actions, a somewhat indemnity clause, if you want to refer to it as that.
Oh, good examples. Thanks for those. In conclusion, what advice would you give to employers or farmers to avoid vicarious liability?
One should always ensure that the correct measures are in place and that the correct preventative measures are in place. This entails briefing your employees and making sure that they are fully aware of what they can and cannot do, and to ensure that they do not commit some wrongful act. It's also wise to ensure that you have an indemnity clause in your contracts as well. Should you require any of this, or to ensure that you are fully compliant, I suggest that you contact your attorney to ensure this.
Mark, thank you for clarity and your good advice. And that was all about vicarious liability. It's clear that there is no clear-cut scenario in which an employer might be held vicariously liable for the employee's actions. What is clear, however, is that you take the necessary steps to avoid such. Mark, thank you for your time.
Thank you.